Cause number 41E2602204, Antonio.
Fuck y'all in this fucking ass court.
Judge, you ordered her to.
Ma'am,
Yes, Judge.
do not argue with me. Got it? I know you don't. Apparently you don't. So back away from the podium. You don't understand. You want to argue. I'm not arguing with you. You got it, counsel? You got it? No, you don't. Back away from the podium, I said, right now. Kennard, Stephen James Kennard, 26I-707-676. All right, Mr. Kennard, your name?
The record Cena covered white appearing on the council president.
Good morning. Ms. Alloway, I'm going to need you on Zoom here. Your name, sir?
Steve Kennard.
All right, so and you guys are comfortable saying this is going to trial?
Judge, today is again time for our final pretrial conference in this matter. This is my third time appearing here. We appeared on 5/5/25 and the court.
26, you mean?
26, and the court entered an order that the complaining witness must appear.
Where is the complaining witness?
It's my understanding that the complaining witness is in Arizona in an alcohol treatment facility.
All right, let's get Ms. Alloway here. Where's she at? 237?
Yep.
I mean, was I aware that she was in Arizona? I doubt I would have required her. Can I have
Your
Ms.
Honor,
Alloway
I'm
come
on
in here,
Zoom.
please?
Yes.
Thank you. Can't
Judge,
believe I would order somebody to
She's
fly
on
from-
Zoom, Judge.
Yeah, I wouldn't order somebody to fly from Arizona if I was aware of it, unless I was really head involved with it.
And I don't know if she's in Arizona at the
We're gonna find out.
judge, but
We're gonna find out. Your name, ma'am?
Bonnie Lynn Marion Stewart
Where are you now, ma'am?
in Tucson, Arizona,
How long have you been in Tucson, Arizona?
since May 7th.
So you left 2 days after this, right? After the pretrial? That was on May the 5th?
Yes, and I was trying to log in on Zoom, but it wouldn't let me. So my
Let me
apologies.
get- Is Ms. Alloway in here yet?
I'm on Zoom, Your Honor.
Okay. Can you come in here? We're gonna set a trial date.
Okay, no problem.
you have a trial date.
June the 26th. But I want to make sure we're all set with instructions.
Yes, Judge, but just for the record, when we appeared on May the 5th, the court was very clear and entered the order on the record that if the complaining witness did not appear for the final pretrial conference, that this case will be dismissed. She was.
What's up? Your name?
Morning, Your Honor, Nora Oliver, the county.
Okay, so can I cut this short?
Judge,
Can I cut this short? I'm not dismissing this case because she went into inpatient treatment 2 days. Listen to me, please. I'm not dismissing this case because she went inpatient 2 days later. Otherwise, I should order every lawyer on every case and every party on every case to come in here in person, and I don't do that. I got lawyers on Zoom all day long. I'm not revisiting it. You can take it up on appeal. Any court that throws this out, I don't know what to tell you. She's here. Has she conferred with you, Ms. Alloway?
yeah,
All right, that was the purpose. So let's not talk about that.
for the record, Judge,
Counsel.
if I could Zoom and I was told that I would need to appear.
I'm not going to argue about it. If she's trying to make herself, she's an inpatient. You're an inpatient, right?
Yes,
I mean, she's trying to help herself.
I understand, Judge, but on 5.
Ms. White, Ms. White, Ms. White,
Wasn't.
Ms. White. Listen to me. I've heard enough. She doesn't have to be here on 5/5. No judge ordered her to be here on 5/5. Did any judge in the country order her to be here on 5/5? If they did, tell me who. If they didn't, why talk about it? They don't have to be here every time.
Judge, you ordered her to.
Ma'am,
Yes, Judge.
do not argue with me. Got it? I know you don't. Apparently you don't. So back away from the podium. You guys are figuring out a way when you're coming back and putting the giving me the jury instructions, and we're proceeding June the 26th. You don't understand. You want to argue. I'm not arguing with you. You got it, counsel? You got it? No, you don't. Back away from the podium, I said, right now.
If you want to email me the jury, so I'll be just.
No, you're not. You want to argue with me. I don't know why you wanted to argue with me. You want to argue with me. I'm not going to argue with you. They don't pay me enough to argue with people or lawyers or anybody else. I'm telling you.
The prosecutor has indicated to me that she's going to CC me.
I will get the prosecutor in here when I'm ready to call the prosecutor in.
Okay, I'm not in any rush, Judge. Just
Good. Stephen James Kennard, 26I-707-676. Okay, Mr. Kennard, your appearance. Where's Mr. Kennard?
I can tell, PPA as well as well.
Hang on one second. I need to talk to you and the prosecutor on the one file. I'm confused. I mean, you and the defense lawyer on the one file. I'm confused. All right. Is he out there? All right. Here's what, then I really covered everything. So let me get your appearances here. It's 26I-707-676, Stephen James Kennard. Name?
Good morning, people.
Name?
Seen a white.
When can you get this jury instructions to me? I want to be clear about this. I'm going to ask you two to agree to them. If you don't or can't, and that's fine, we'll argue what you guys can argue, whatever the differences are before the trial. I'd like them in final form, listing everything, all the instructions, and I'd like them by, can you get them to me by June the 17th? Okay, jury instructions due
Would you like,
June 17th. Trial will be June 26th at 8:30.
would you like defense and I to confer prior to submission or?
Oh, yeah, I'm gonna hope that you guys have talked about it, and if you can't resolve, if you can't resolve any issues, I'd rather you guys tell me and we set it the week before, what would be June the 19th for any hearing on differences in terms of what jury instructions you would like. But this is pretty clear. This is the message. Right, I know.
But I'd just like to ask the court or the people, if they've confirmed whether or not the complainant will be back in the state.
Complainant has to be here for the trial.
She said she will be.
Yeah, she's gonna have to be here for the trial, or else I'm gonna have to, I will dismiss it if she's not here in person, okay? Anything else? Thank you both. All right, I need to talk to you guys and continue. Come on back here.
All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access on our civil docket, both in the courtroom and also online. Also, I've got a fake background behind me with a QR code that lets you know that we are in the middle of our biannual public satisfaction survey. So you can use that QR code to access that. There are also written forms in the hallway. And if somebody wants to participate through the QR code and can't manage to access that code from the device that they're on, which I can never manage to do myself, just reach out to the circuit court office and we'd be happy to get that form to you. So we have a status conference at the court scheduled in Lowry v. Michigan Unemployment Insurance Agency. It's a administrative appeal. It's file 26-9188AE. And Mr. Lowry is in the courtroom representing himself as the appellant. Good afternoon, sir. And go ahead and place your appearance on the record, Ms. Bryn.
Good afternoon, Your Honor. Assistant Attorney General Tara Bryn for the Unemployment Insurance Agency.
Okay, so I had entered an order back in March directing the parties how to proceed because I noticed on review that I had given Mr. Lowry a bit of bad advice or bad direction and told him that it was his job to get the record, which it would be in most appeals, but on review, that was the job of the Unemployment Insurance Commission or agency. So I entered an order to that effect. We didn't see it filed, so we'd set this status conference for today. I will indicate that on today's date, we did in fact receive the certified record.
Great.
So that addresses the question that I had about that for the status conference. And so, Mr. Lowry, what that means for this appeal, I am going to direct the clerk to, on today's date, sign the notice to the parties that the record has been so filed. And that means that now we can trigger the briefing deadlines. So, Mr. Lowry, that notice being signed by the clerk on today's date, your brief on appeal explaining to me why you believe that I should reverse the action of the agency would be due not later than June 1st. June 1st is your deadline for your appeal. And then once you file your brief, the agency has 21 days to file a response brief. After they file their brief, you have 14 days to file any reply that you wish. And then at that point, the case comes to me to review the briefs and see if there's a need to schedule it for oral argument or not, and then to proceed on the merits of the appeal. Do you have any questions for me, Mr. Lowry, about that process for the appeal?
Well, I didn't quite expect a June 1st date for the brief. I was kind of waiting for the interrogatories, but doesn't look like anybody wants to answer the questions.
Well, that's a separate matter that I'll wanted to address since we're here anyway. Mr. Lowry, you keep filing various pleadings and discovery requests and other miscellaneous pleadings. And I want to tell you, everybody from the defendant to me are pretty much ignoring those. And here's why. This is an appeal. In an appeal, you filed a claim of appeal. In an appeal, here's what I get to do. Review this record and this record only. My appellate jurisdiction is limited to this is the record. Then you explain to me why they did something wrong. They explain to me why they didn't. And then I make a ruling. There's no discovery in an appeal. There's no new evidence in an appeal. You are not entitled to submit interrogatories to anybody. When you do, they can just object to them or not answer them. Heck, they could throw them in the trash as far as I'm concerned. It's an appeal. There's no discovery in an appeal. An appeal is limited to the briefs. You filed an appeal. So we are following the appeal rules. This is not a freewheeling forum for you to bring any complaint you want in the universe against these folks. This is an appeal from an agency action. And we're going to follow the rules for that appeal. Do you have any questions for me about that?
Well, what I've read, some of that I can understand. Only in this case, my request is for fraud. And in the reading of the act, that's excluded from non-interrogatories. And I had mentioned that before, but as you said, they just ignored it.
Well, because I'm looking at, I don't know, what act are you referring to?
The Michigan Unemployment Compensation Act.
Okay. Well, that's an argument you may have on appeal that the agency prevented you from submitting evidence of fraud, right? But the appeal to me is not a case in front of the agency. It's an appeal to the circuit court from an agency action. My jurisdiction is fairly limited. It's to determine whether the agency made a correct decision or not. This is not a lawsuit. This is an appeal. So there's no discovery in the circuit court on this appeal. And, you know, the defendant, frankly, has just been kind of not responding or objecting to your requests. They haven't asked for any sanctions or anything, but they could, because it's frankly, it's frivolous for you to file those things. You can represent yourself if you want, but you don't get to make up your own rules. We have to follow the appeal rules. So if you're representing yourself, you got to follow those appeal rules. And here's the bottom line. All the other stuff you're filing doesn't matter. The appeal record has been filed. Now you have 28 days, so till June 1st, to file your brief. Then they file their brief. You can file a reply if you want. And then I decide the case with or without oral argument as I see fit.
28 days from today's date.
Yes, sir. Yes, sir.
And you're saying it's June 1st and it's May 17th.
Oh, you know what? I must have miscalculated that. You're right. You are right. May 18th. Oh yeah, I'm sorry. I just calculated 14. You're right. You're right. 28 days of June 15th. Yes. June 15th. My apologies, sir. Yes, sometimes I say dates wrong.
I can understand them wanting to lean to the appeal, but this is just a stepping stone from the beginning, and everything moved forward is always an appeal. And this is going before the circuit court, not the appellate court. And I read where the the appellate court has limitations.
Well, I am an appellate court in this case because you filed a claim of appeal. I'm not the agency. In an agency action, then the circuit court jurisdiction is an appeal from that action.
Well, if you don't have complete files furnished by the court, by the agency, how can you make a decision?
That's what the certified record is. They submitted the certified record today's date, so you should get a copy of that.
And they only put one area in it. And this has been going on since 2021.
I don't know what to tell you, Mr. Lowry. I have to follow the rules. And whether you think I should ignore the rules or come up with new rules.
No, I'm not
that you like,
asking you to ignore the rules.
I got to follow the rules. And the rules are, that's my record. You all file your briefs, and then I decide the case. I am sitting in appellate jurisdiction in this case. I am an appellate court of the agency action. So that's how I have to proceed. If you want to file a lawsuit against the unemployment insurance agency or the schools, that's an entirely different action. And I can't give you any advice about whether you have a valid lawsuit that you could file against them in this court or another court or federal court. I have no idea. You know, you can take whatever remedies you think you have at law. What you have filed in this case is an appeal. And so I'm going to follow those rules. Right.
So I'm stuck with what they control coming into this court, sir.
You are stuck with the record on appeal. I don't know. I don't understand the nature of your question. If you think that they have filed a record that is incomplete, you can file a motion in front of me saying that the record is somehow wrong or incomplete. But I'd encourage you to review the appeal court rules to see how to do that. A lot of the stuff you've been filing is if this is just some standalone lawsuit, which it is not. Okay. Any other questions for me, Mr. Lowry?
Well, this case started with civil rights violation, and somehow everybody has been able to dodge that issue up to date. And I can't see why I would come to a courthouse and be ignored for that reason. And it's gone all the way through. No one, yourself included, addressed the civil rights action. When I started this, we were threatened, the bus drivers were threatened that they could not draw unemployment and they would fight it. The following summer, the school allowed our female bus driver to draw unemployment. And that has never been addressed by this court, by the attorneys, or by the agency. They've all ignored it.
Mr. Lowry, all I can tell you is my jurisdiction is triggered when people file cases. You filed a case and it was captioned a claim of appeal, and you appealed from the agency decision, and you went through the appeal to circuit court and you say it's a fraudulent denial. Well, so I have my appellate jurisdiction. A lot of the stuff you're talking about, if you think you have a lawsuit against the schools for some civil rights violation, you pursue whatever remedies you think you have.
It's not against the school, it's against the system.
Well, whatever.
You know, just because I'm a male, we don't have a right in the courtroom or in the agencies.
You have the same right in my courtroom as anybody of any gender, Mr. Lowry, and I'm going to exercise my authority under the appeal rules, and I'm going to apply those rules to your case. So I've explained to you my jurisdiction in this case is appellate jurisdiction based on what you have filed. So I'm not going to get into a long debate with you about that. That's true. If I did anything else, I would be breaking the law. So you've got your appeal deadline and your briefing deadline, and I encourage you to follow that. Ms. Bryn, anything further on behalf of the appellee?
No, thank you, Your Honor.
All right, thank you. So as soon as we get all the briefs, I'll review them and likely schedule it for oral argument. Everybody have a good day.
Thanks, you too, Your Honor.
House number 0, Kenton Place Apartments LLC versus Brianna I don't know if it's Armstrong, and they just don't have.
Brianna
Okay.
Armstrong. I'm
Okay,
Nan.
that's what I figured. And all occupants? Brianna?
Yes, ma'am.
Okay, oh, there you are. Kenton Place Apartments? Anybody here for Kenton Place Apartments? That one's going to be dismissed. Did you pay it?
I actually tried to pay it, but Miss Brenda Nunez told me that she refused to take my payment also, I had worked with the city of San Antonio, and Miss Nunez told the city of San Antonio, because they were trying to pay it out as soon as possible, and she told them that she would not take my payment because I wouldn't make June or July's rent. Also, I have also been living in an unsafe living
Okay, ma'am.
environment.
Ma'am, I just dismissed it for you because they didn't show up, but good luck to you, ma'am.
Thank you.
Thank you. Cause number 41E2602204.
Dismiss.
They're saying that they're here at Hinton Place, but I guess they're having a hard time with Zoom.
Oh, okay. Try, what is it? *6.
Excuse me, Judge.
Hold on. I'm waiting for the Kenton Place to come back on. I don't even see them.
Hinton Place is under Brenda Nunez.
Oh, okay.
Can you hear me, Judge?
Yes, Miss Brenda Nunez. Yes, we can hear you.
Yes,
Okay.
I'm here. Sorry, I had technical difficulties.
Okay. Problem.
Hi, Judge. I'm sorry. I wanted to say also, before you had cut me off, I had been living inside of my apartment. If I'm able to display these pictures inside of the Zoom, where I have a big hole in my ceiling where I've been having rats and possums come into my apartment complex.
Okay. Ma'am, I'm trying to tell you that this is eviction court.
And I was stated that I was told that I'm
Excuse
able
me.
to speak
Can
about
you
this.
mute her, please? Can you mute her, please? Ma'am, you need to listen and do less talking. We are an eviction court. We are only going to discuss rent today. All those things, I'm so sorry you're living in those conditions. That is not before the court today. You cannot withhold rent for any kind of repair and remedy. There is another way, avenue, path that you can go down to get your satisfaction in whatever way, monetarily or whatever it is, but it is actually not today. Today is rent. I need to know if you paid it or not, and you told me earlier that you did not pay the rent. And the other thing is, for all these tenants, just because you do file with the city of San Antonio and you are approved, the landlords don't have a mandatory order that they have to accept this. Some people act like, oh, they won't accept it and they're all upset. Well, they don't have to accept it. Okay? There's not a law that says just because you were approved that the landlord has to take it. So you need to please stop talking over me because you do not know the law. And I would appreciate it if you'd be respectful, but we are going forward with this. So now, Miss Brenda Nunez, how much is the monthly rent on this one, please?
It is $10.79.
$10.79. Any subsidy, ma'am?
No, ma'am.
Okay. And what months are you seeking, please?
April and May.
So it's $21.58?
Yes, ma'am.
Okay. Ms. Armstrong, would you like to say anything else that pertains to the rent? Did you pay the $21.58 or did you not pay?
I tried to pay the rent after the court, and she refused to take my payment. As I stated, I also went to her and asked her and told her, I also have emails of the city working. When I also called her and told her, would she take my payment? She told me no. I did try to make a payment, also with myself and the city, and she both told me no on both behalves. I've never tried not to make my payment.
Okay, excuse me. Ms. Nunez, what is the ledger balance on this case?
The balance on this one is $2,759.71.
Do you have $2,759.71?
Yes, I do.
Okay, so what's the deal, Ms. Nunez? Why won't you take her payment?
Ma'am, she is trying to have the city of San Antonio pay. When I spoke to her last week, I had told her, you're not relying on San Antonio to pay us. And she said no. So she has not brought me no cashier's check in the total of the $27.59 that we are requesting. I spoke to the worker that's helping her, and I told her, because on the form it says that I cannot file an eviction for the following 60 days if she fails to pay. I cannot risk us not receiving rent for the future months.
Okay, so you're telling me that she did not bring a cashier's check or
She
a money
did not.
order? Okay,
That is correct. She
I'm
did
going to
not.
go forward.
Okay.
The judgment is for the plaintiff in the amount of $2,158.
Have my rent, but why should
Judgment,
I pay
interest, and
rent when
possession.
I'm living in an
Setting the appeal
unstable
bond at
situation?
$2,158, and you do have 5 days to appeal. Good luck to you, ma'am.
Oh, she's not getting
Clause number
shit, 'cause she's not
could you
getting
please-
shit. The fuck?
Cause number 41E2602204, Antonio.
Fuck y'all in this fucking fuck ass court.
Cause number 41E2602380, Ralph Del Toro versus Valerie Delgado. Hello. Good morning. How much is a monthly rent on this one, please?
1,500. I'm sorry. April 9th due. Total cost is 2,600. Court fee is $290. I
Okay.
believe the grand total is $28.90.
Okay. It'll be the rent and then we will add the court cost. Okay. So, did you pay the last 2 months? Okay. What is his ledger balance? The ledger balance, like, do you keep an accounting of like late fees or anything like that or no? Okay. All right.
It's just a order agreement that we paid, or they pay us.
Okay. So there's no lease. It's just month to month.
No, we have a contract for 1 year
Okay.
and we're not renewed the contract.
Okay. And when did the contract end or when does it expire?
The 1st of April is the last day of the contract. Well,
So they're holdovers basically.
yeah.
'Cause they didn't move.
carried over
Yeah. That's
the
called.
contract and they didn't make an attempt to contact us at all.
Okay.
And we're asking for the house back.
Okay. So y'all are living there. The contract expired on April the 1st. And so y'all are you still living there or did you move out?
So the reason why I believe that he is even filing for an eviction, I think it's a retaliation on them.
Okay, no, we're not here for any of that. There's another day, another court for that. I'm here for the rent. Did you pay the rent or not? You're still living there and you can't live for free. Even if you don't have a contract, it's month to month.
Correct.
So,
We had a verbal agreement. They still have our security deposit that they would pay for April.
oh,
We
no,
had an agreement.
that's not how it works. The security party deposit does not
Even if you
take
said so.
place of, well, did you say so? Okay. It does not take place, sir. Do you have it, sir? Do you have it in a text message? Do you have it in an email? Do you have it in a letter?
No.
Okay. So, security deposit does not take place of rent. You know, what the security deposit is when you move out, whatever damage you do to the property, they take that out of the security deposit. I don't know why I can't talk. I think I'm just exhausted. I'm going so fast. Okay, so it's not to replace the rent, right? Okay, so my question to you again, did you pay the last 2 months of rent?
I'm supposed to pay this month when that contract is ended in April.
He doesn't have to have a contract. There's a lot of people that move in houses that don't have contracts. It's called month to month. You still have to pay. You're living there. You can't pay for free.
They never trust
Okay.
that.
Okay, sir. I'm not going to argue with you, but you know, he still has to pay the insurance and taxes. He doesn't get that for free. So you're paying you're living there for free. He's paying for you to be there.
But he not. Some type of pay.
Do you live there still? Excuse me, sir. Do you live there? Did you spend the night there last night?
I did.
Okay, then you're living there for free. So the judgment is for $2,600 to the plaintiff, cost of court, post-judgment interest and possession. Setting the appeal bond at $2,600, You have 5 days to appeal. Good luck to you, sir.
Love it.
A person at the Wexford County Jail, please state your name for the record.
Kyle Earl Puffer. Your Honor.
All right, this is case number 26-1342 SM, the people of the state of Michigan versus Kyle Earl Puffer. Mr. Puffer, we are here for alleged bond violations. It is alleged that you failed to appear for random alcohol testing as ordered on April 21st, April 26th, May 1st, May 3rd, and May 4th. That you failed to appear for a drug test as ordered on April 21st, April 26th, May 1st, May 3rd, and May 4th. That you violated the no contact order on April 21st, April 26th, and May 1st. That you failed to check in for weekly services, and that you failed to appear for a pretrial on May 6th. You do have the right to have a contested hearing in this regard, in which the prosecutor would have to prove to the court that you did in fact violate the terms of your bond, or you could plead guilty to those violations. Mr. Shantz, have you had the opportunity to discuss this matter with Mr. Puffer?
I have, Your Honor.
What is the plan for today? Oh, hold on. He has Michael Pieknik. Did we let him?
Yeah, and he didn't respond, and I did let him know.
All right. Mr. Puffer is represented by another public defender. Mr. Shantz, have you had any communication with that attorney at all?
I have not. I didn't find Mr. Puffer in our system.
He's represented by Mr. Pieknik, and we reached out to him, but had not had a response. What was the plan?
I believe it was to contest the bond violations, Your Honor. But I don't want to overstep if there's another attorney.
So because that attorney is not present, we will go ahead and we will set this for a contested hearing. I believe that is appropriate, and that way Mr. Pieknik and Mr. Puffer can then discuss matters. That gets us to bond. Ms. Lawrence, any comment regarding bond?
Your Honor, I would ask for a remand pending hearing. Essentially, all these bond violations just add up to him absconding while on bond for quite some time. Not followed any of the orders of the court. He has not been testing, whether that's for drugs or alcohol. And he has not been keeping in contact with community corrections. But I ask for a remand.
Thank you. The court is going to remand Mr. Puffer until we have the hearing. I believe that is appropriate, given his fail to test, his fail to appear, at least alleged, and his fail to comply with the no contact order. Mr. Puffer, I'll give you a moment, but I don't want you to say anything about the facts of the case, okay?
Yes, Your Honor.
What is it you would like me to know?
Well, it's already remanded. I didn't have a phone. I just had a lot of stuff going on, man, and
Okay.
I could go drug testing and whatnot. Like, is there any? Like, I'm not on drugs. I just went to court
Well,
yesterday.
Mr. Puffer, I wouldn't know that because you're not testing. So I'm going to remand you for now. You can certainly discuss that with Mr. Pieknik, and then he can discuss those issues with the prosecutor or present them as a defense at the contested hearing. All right?
Sir,
Yes.
something I could get out of this. I'm looking for a word to say that could help me. Like, I'm really in a tough situation right now, Your Honor, and I don't mean to do this. I know you don't want to hear it. I just, like, dude, I'm 33. I've been in a lot of trouble. Like, I ain't trying to run over misdemeanors. Like, I need to get out here and work. My mom's got sclerosis of the liver. My daughter's birthday's in 10 days. And, like, I'm really not doing bad. I just didn't have a phone when I was homeless.
Okay, Mr. Puffer, again, I don't want you to say anything about the allegations because that could be used against you and you're on the verge of making admissions that I don't necessarily want you to make today. I will state my position again. I did give you that opportunity and you weren't following through allegedly with the terms of bond. So you will be remanded until we have the hearing. Thank you, corrections.